Yes, ma'am.
And this is cause numbers 26 DCCR 0277, 278, 279, 280, 281, 282, 283, 284, 184, and 0490. And Mr. Bonton was examined for competency to stand trial by Dr. Grimsley. I received that report. I'm going to take judicial notice of the court's file in all of the cases. The report is dated April 14th of 2026. The finding in that report is that Mr. Bonton is currently...
This is the moment the entire courtroom shifts direction. The judge isn't deciding guilt yet, she's deciding whether the defendant is mentally competent to even stand trial. And once that competency report comes in, everything changes.
Not competent to stand trial, and that inpatient treatment for competency restoration would be warranted. Is there any other evidence with regard to competency?
Not from the
state, Your Honor.
At this time, then, I am going to find that Mr. Bonton is not competent to stand trial.
Whoa, did you catch that? The defendant claims there's a government chip in his knee controlling him through his phone. At this point, the courtroom isn't reacting with anger anymore, it's reacting with concern. And legally, statements like these can become critical in a mental competency ruling.
Hang on, let me say what I need to first, and then I'll let you.
Illuminati, man. I got a government microphone chip in my left knee, my right hand. I've been to the hospital. I understand the courts, man. George Bush know me. I'm not lying about nothing. I testify and take a lot of tick tests. I'm innocent. I got the right to freedom of speech, man. I'm asking for probation 2-year cap. I go home today because these people on the Illuminati application on their phone is manipulating the government system through my chip. I do hear voices. I don't take medication, and they force you to take medication and join S. Behavior Center. Coach Lewis know me. I was sitting here. I had an aggravated robbery job. I shot a 9mm 2 times, one third way.
Mr. Bonton, you can go.
They shot that 45.
Go back with the bailiff. You can go with the bailiff.
Sorry, man. I'm sorry about that.
All right, I'm going to find that Mr. Bonton is not competent to stand trial.
Sacrifice him, man.
That inpatient restoration treatment is warranted. Order that he be sent to the appropriate facility for a period of not to exceed 120 days from the date he gets to that facility.
No.
Well,
Hey,
A lot.
y'all should have went back.
All right, let's see. Mr. Eckhart, you've got Mark Marceau, 3 cases.
okay.
Good morning.
Morning, Judge.
Get on, man. Get on, man.
I think that needs to become a full case.
I'm gonna do it the right way. Hey, can I go with my stuff, man? If they rather be murders than rapists, don't keep their pace, bro. But a brother, the fucking nigga talk. Right. Y'all gotta keep your fucking pace.
Good morning. Are you Mark Marceau? Are you Mark Marceau? But true to prior convictions, making this offense a second-degree felony. The agreement was for a cap of 8 years in prison. I received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor, and I want to commend Justin Riley on what a great report he wrote. He really did it.
Ms. Malfino?
I have, Judge.
Any additions or corrections?
None, Your Honor.
Judge, obviously I am aware that the criminal history is of concern to the court. As you know from the indictment, the underlying offense itself is a state jail felony, and the offer was made just predicated on the nature of that offense with these priors. I'll defer to whatever you think is appropriate if in fact you think 8 is enough. No, I'm intended.
So I want to make sure, what's the status with parole? You're on parole, correct?
Yes.
Have you had a hearing out at the jail? Have they come to the jail for a hearing? Have you talked to anyone with parole about this case?
Somebody called over there. I don't know who it was.
Okay.
There's something about parole, not parole, but like, I don't know, I don't understand what he was saying.
Okay, there's a hold on him, correct? Sure. Mr. Parker, you may proceed.
I've had this same issue trying to figure some of this stuff out, Judge. I've talked to him, and the facts of this case, I mean, to my understanding, what the probation calls it, he was living in a transitional house, and I've talked about where he's going to live. He intends to go back to the transitional house, and he was working there in the kitchen, and the facts are that he was out, it started pouring down rain, he went to a house, he was on the back porch that he thought was vacant, and he was on the porch getting out of the rain, and 5 cop cars pulled up, and as he says in his report, I asked him, why did you run? And he said, well, 5 cars pulled up and I got scared. And I mean, I've heard that a lot, but I mean, I think he's sincere in that, not that it's justifiable, but that's what happened. He wasn't trying to break in the house, and that's what happened in this case. And I would point to the probation officer that thinks he might respond better to a structured guidance than to extended incarceration. It's in the top paragraph on page 5, the last sentence. And that's kind of my position. I think the last time he was in trouble, well, he's obviously been incarcerated, but it was in 2017. I clearly think that the probation office has pointed out everything about him thoroughly in this report, and just going back to his childhood, how he's raised and how he's lived, and his educational standing and his mental capacity. I think he's competent, but it's not as high as a lot of people that are out there, and he struggles to get by.
The burglary, I'm just glad we're not here on an offense involving him actually being inside someone's home or involving a child. So, but based on the mitigating factors pointed out by Mr. Riley, I'd ask the court to consider the 8.
So, Mr.
And here comes the judge's final reality check. Despite arguments about his difficult background and cognitive struggles, the court focuses on one thing: repeated criminal history. 6 prior prison terms, and the judge decides enough is enough. But what do you think, prison or treatment?
Cogdill, I appreciate your attorney's argument. I can see that there's some issues cognitively. However, there's no doubt that you understand what's going on, right?
Yes.
Yeah. So you've been sent to prison 6 times, and you're currently on parole for 3 burglary of a habitations, delivery of a controlled substance, evading arrest or detention with a vehicle, and then and it makes no sense to me that you were on parole and had opportunities through parole to get any help that you needed, and you didn't take advantage of that and were out doing whatever you were that you shouldn't have been doing, and then ran. So at this time, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of evading arrest or detention with previous convictions. Find those prior convictions true that you pled true to. Sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal.